I'm going to let the moderators speak, but I just want to explain that our first speaker for the panel is joining us from Washington, D.C., which is why he's right there. But then I'll get out of the Steve or okay.
Good morning. My name is Elise Myer. I'm helping Steve moderate. I want to thank Melissa for having me here today. It's really exciting for me to be here. I graduated from Washington College of Law in 2010. I was a Marshall-Brennan Fellow in my third year of law school. I moved out here upon graduation, and I'm a public defender out here. I like being involved in this type of stuff and in the program and giving back in any way I possibly can. So thank you for having me. And this is Steve. He's going to introduce himself.
Hi, my name is Steve Martyn. I'm a second-year student here at the University of Colorado. I'm also a Marshall-Brennan Fellow and have been working with Melissa since, well, really my first year. So I've really enjoyed the opportunity to get out and teach constitutional law to high school students in the Denver area. Dr. Jamin Raskin. He's a professor of constitutional law and legislative process at American University's Washington College of Law. There he directs the program on law and government as well as the Marshall-Brennan Constitutional Literacy Project. Today, Professor Raskin will be speaking about distributing constitutional knowledge and the effects it has on law schools. So without further ado, we'll send it to Professor Raskin.
Thank you very much.
Wait, Jamie, wait 1 second.
Jamie, just a second. We can't hear you for some reason. Do you want to try again?
Yeah. Can you hear me now?
Yes.
Yes.
Good. Okay. Well, hello, everybody. First of all, let me just say I'm mortified and heartsick not to be with everybody in Denver at basically the only academic conference I ever really wanted to go to in my whole life. Maryam and Melissa can explain to you the absurd reasons for my having not to be there. But I'm very sorry to miss it, and I'm impressed by everything that's going on. I will try to be as quick as possible because I know it can be annoying watching somebody on Skype, and if it gets really annoying, somebody signal me and I'll just stop. The French have an amusing expression that came to mind when I started to write my article, which is they say, well, yes, it works in practice, but does it work in theory? I thought about that because the Marshall-Brennan Project has been working in practice now for more than a decade, and yet until Melissa had the inspiration to do this conference on constitutional literacy, we never really forced ourselves to sit down and to both document and record what we've been doing, but also to explain it and to theorize what exactly we're doing. So I found this to be an enormously beneficial exercise, and I just want to salute Melissa for having convened all of us and brought us together to do this. I think that I'm going to speak about the Marshall-Brennan Project because it's, of course, the one that I know best, but it would apply, my remarks, I think, apply in general to other constitutional literacy projects that may exist out there. I would think that we're offering three essential services that are being rendered on a daily basis, really, by the project. One is to society in creating a pipeline for constitutional knowledge and literacy into the high schools and into the broader public culture. The second is we are rendering a service to the field of constitutional law within law schools, especially to all of those scholars who have begun to rally around the flag of popular constitutionalism, because as I want to argue, the Marshall-Brennan Constitutional Literacy Project is popular constitutionalism in action. And third, we are rendering a broader service to the law schools, both in creating a pipeline into poor, working class, and minority communities so that we are educating young people about the Constitution and the Bill of Rights and finding those who have a real passion for it, who might be able to go to law school later, because obviously we're facing a real problem with declining enrollments from students in minority communities. And finally, related to that, I think that the project offers a kind of answer to the current savage onslaught and critique that's taking place against law schools and against legal education in America. So, but I will try to spend a few minutes on each of these things and go through them, and you know, and then of course, if anybody has any questions, I'm happy to do that. The basic premise, I think, is that there are those of us in America who have a surplus of constitutional consciousness and a deficit of contact with real-world institutional experiences. And conversely, there are lots of people, especially lots of young people, who have a deficit of constitutional knowledge and understanding, and yet a surplus of the kinds of practical institutional problems that end up becoming the source of constitutional conflict. And so the Marshall-Brennan Project puts the two groups of people together, those of us who are drowning in so much constitutional knowledge that we have hundreds of law reviews and law journals in America with thousands of law review articles every year that never get read by anybody, putting those people together with the thousands of people or tens of thousands of people that we can reach who have lots of basic problems relating to things like drug testing and locker searches and censorship of student newspapers and yearbooks and so on, and yet have no access to real constitutional analysis and knowledge and understanding. Let me just quickly tell the story of how it came about from my perspective, because I think it is an excellent illustration of what I'm talking about and also of the possibilities of popular constitutionalism in action. I had received a phone call from some high school students at Blair High School, which is a high school in Silver Spring, Maryland, saying that the school system was not going to honor the agreement that they had with the school system, which was to run on a monthly basis a cable TV show in a debate format. And they had scheduled for this particular month a debate. This is back in 1999, or 1997 rather. They scheduled a debate about gay marriage, and they had two conservatives and two liberals on the show debating whether gays should be able to marry. And they had received an email from the manager of the station saying, we're not going to go live this month. Record the tape and send it to us. So the students duly recorded their show, sent it in. Then they get an email back from the manager saying, thank you for your submission. We are not going to be running Shades of Gray this month. We'll see you in the November show about class size. So the students and the teacher were very upset because they thought it was a great show. In fact, I think it's probably the best discussion I've ever seen, even to this day, about same-sex marriage. And they called me and they said, well, do they have a First Amendment case? Can they somehow sue to stop this? And so I asked them, why was the school system not running their show? And they said they didn't know. I said, send an email and ask why they're not running the show. And I kind of talked them through the law a little bit. So they get an email back from the school system's cable manager saying, well, you can tell Professor Raskin that our reason for not running the show has nothing to do with the content of the speech, but it was because of what the speakers were saying. So I said, well, that's as close to a smoking gun as you're ever going to get in a First Amendment case, and I'd love to take it. I wanted to go right to court, but the students said, well, there is this internal appeals process. And so we pursued the internal appeals process, and we started by my sitting down with them and talking to them about the Tinker decision, about the Hazelwood decision, about Rosenberger versus University of Virginia, and how you can't censor religious speech because the objections that were originally raised about the speech on the show was that it was too religious, people were talking about God and so on. And they got very excited about it. And nobody had ever really talked to them about these cases before. Even Tinker versus Des Moines, which is, right up there with Brown versus Board as a great speech about student rights. And they went and they educated the student council and the PTA and started a whole movement. They made several hundred copies of the tape and sent it out to people. And by the end, they had a real mass movement, and the school board voted to lift the censorship of the superintendent on a vote of 4-3, and it it ran, I think, a total of 12 times, and people actually watched it. Of course, if they never censored it, nobody would have watched it in the first place on their channel. But anyway, so I learned from that the schools that should be educating people about their rights in school are actually trampling their rights. And nobody, the students, the teachers, the principal, nobody had any kind of context for really understanding what was at stake in a conflict like this. I got contacted by a bunch of other high school students saying, can you represent us about drug testing, about them forcing us to cover up our tattoos, about this and that. And I realized I couldn't do that, but it struck me then that we needed a book for students, and that became We the Students, which the Supreme Court Historical Society sponsored, and then a project which I got together with Steve Wormeal to form. And of course, Steve is Justice Brennan's biographer, and he found a number of old speeches and essays by Justice Brennan and Justice Marshall about the importance of educating young people about the Bill of Rights and about how the Constitution works. So the project, as you guys know, is spread to 20 law schools now, and I think it is sort of a daily on-the-ground answer to the complaints across the country that law schools are necessarily selfish, exploitative, out of touch, and so on. Now, the core theory of the project and how it works is, I think, classical American pragmatism and democratic experimentalism. We modeled it after Bob Moses and the Algebra Project in Mississippi. And Bob Moses had talked about movements like the Civil Rights Movement needing principles of common conceptual cohesion. And in the voting rights struggle that he did in Mississippi, he said one person, one vote was the organizing principle. And we basically have a theory of one nation, one constitution. And he said what you need when you're coming from the outside is crawl space within existing institutional structures. And he found the crawl space within the black churches and within the 1957 Civil Rights Act and the Civil Rights Division of the Department of Justice, and we found our crawl space in the public school systems and the need that they have to get an infusion of energy and vision from the outside to support them in the very hard work that they do. And so we basically followed that theory. One of the first issues that we encountered in finding some reluctance on the part of school principals and administrators was that they suspected that if we're in there with law students teaching high school students about their rights, that it could become a really subversive project and everybody would end up getting sued. So from the very beginning, we linked rights to responsibilities. We pointed out that if I've got rights, it means you've got rights, and that means I've got a responsibility to respect your rights. And so rights and responsibilities inevitably go together, and that really has become a mantra for our project, both in DC and across the country, that we have to do rights and responsibilities at the same time. The curricular focus from the beginning has been about schools themselves. In his book, Democracy and Education, John Dewey talks about the formal curriculum in school, which is what's on the syllabus and what we think we're teaching, and the informal curriculum. And the informal curriculum is how the teachers treat the students, how the school treats the janitors, how boys and girls interact, what happens at recess, and so on. And I realized that we basically were taking the informal curriculum of school, what students learn from how we actually treat each other, and turned it into the formal curriculum, so that we're studying what the law is governing and what the values are governing all of the interactions at school that are not on the formal syllabus. Let's see. So let me just say one final thing about the curriculum project. The MOOC Court program, for those of you who are Marshall-Brennan directors, as you know, the MOOC Court program has become a really vibrant and vital part of the project to go along with the books and articles and other stuff we bring in. People have found it to be a very powerful stimulus to learning. There's obviously a competitive dimension to it, but I think we've always tried to emphasize that the competition goes together with community. and that we are constantly learning together as a group, even if we're competing in small groups as teams or as individuals. And so, but I think that it raises an interesting dynamic because a lot of us are teaching in schools where the students have no shortage of demoralizing messages that they get about their academic capacity and potential, and yet we've been able to show that they can do remarkable things, like the young woman from the Arizona chapter who won the national competition a few years ago. Her father had died, her mother was in prison, and yet she finished first in the country, and one of the judges said that when it came to the Constitution, she was a Stradivarius in terms of her ability to express herself. And so this is an important learning device. At the same time, we know that a lot of students can be very disappointed, and we don't want to demoralize them, and that just puts the burden on us to multiply the different opportunities for students to get awards and recognition in the different things that they do. All right, now let me shift over to what the project is doing for the academics of popular constitutionalism. I go a lot into my paper, but I won't say much now about kind of what the theoretical project is around popular constitutionalism. I imagine that Professor Tushnet discussed it last night. But let me just say that popular constitutionalism reminds me a little bit of what my grandfather told me about Zionism in America. He said, a Zionist in America is someone who tells other people to go live in Israel. And I think about popular constitutionalism as, to a certain extent, scholars telling other people to go and listen to the people or consult the public, or what have you. So it can take on a kind of abstract and formalistic quality. And I think that projects like the Marshall-Brennan project actually get the law schools and law professors who participate directly engaged in popular constitutional discussion and in the kinds of conflicts and problems that later on become the real source of constitutional litigation and adjudication. So I think that that the Marshall-Brennan project gives the law professors involved the opportunity to make the rhetoric of popular constitutionalism real and direct and concrete, both in their own work and in the work of the law schools. I'll just give you one example of this. I had a message from Professor Larry Lessig from Harvard Law School, who is very interested in convening actual constitutional conventions under Article 5 to talk about a constitutional amendment to reverse the Citizens United decision. And he got in touch with me because in my work as a state senator in Maryland, I've been very interested in moving the discussion towards a constitutional amendment on Citizens United. Of course, we've never had direct constitutional conventions meeting in the states as the source of it. It's always, constitutional amendments have always started in Congress first. But I said to him, why don't we go through the Marshall-Brennan project and other similar projects and set up meetings with law students where the law students can enact constitutional conventions to discuss this question. There's a lot of fear of what it would mean to create constitutional conventions. They would be runaway, all kinds of extraneous or dangerous things would take place there. And I said, why don't we practice it and see whether that would happen with the law students and the high school students working together, which is an idea that he liked a lot, and I think that we will hope to move forward with in the next year. But I think that gives an example of how to take an idea that might be at a certain level of scholarly abstraction and make it real by anchoring it in our project, which unites so many different forces and sectors of society. Finally, let me say this. We've got big problems in the academy now relating to different things. Let me just talk about two of them before I close. One is the declining presence of students from minority communities and poorer communities in our entering classes. And the Fisher case before the Supreme Court now threatens further damage with the perhaps total abolition of affirmative action. In any event, the U.S. News and World Report, which we know is focused on LSATs and grades and how many books are in the library, but doesn't have any recognition of diversity as a plus factor in terms of law schools. The U.S. News has been exerting a powerful downward pressure on affirmative action in the schools. And so we're moving in the wrong direction on all this stuff. And the race is on to figure out how to build a pipeline for minority and poor students to get into the law schools. And I know some other people are going to discuss this, but let me just say generally, it seems to me that there's one ineffectual and counterproductive and demoralizing way to do it, which is once a year to have a bunch of lawyers from law firms or law professors or law students show up in a classroom and say, apply to law school, or let's have one discussion and then apply to law school or get on a path to do it. It's a little bit like, I think, one of the presidential candidates who said in the most recent election, if we've got jobless youth, they should just take out a loan from their parents and go and start their own business. I guess it's not bad advice if it's relevant to you, and if it's not relevant to you, then it doesn't help. It can make you feel worse. But the right way to do it is what we're doing, which is to actually get into the schools, get them deeply immersed in an education about the Constitution and Bill of Rights, which will equip them for meaningful democratic citizenship regardless of what happens. But even if law school is not right for most of them, and it won't be, and it shouldn't be, but we will be able to find the ones for whom it is right, and we will be able to coach them and get them through. One of the things that the Marshall-Brennan Fellows do in Washington so well is to kind of supply the role that a lot of college-educated middle-class parents can play for their kids, which is to help with the SAT enrollment process, college applications, and giving them that kind of push that they need to get through it. I've got a friend who works on a college admissions committee, and she said the process is simple. The students apply to the colleges where they have the cutest tour guides, and then the colleges admit students based on how well their parents can write. So I don't know to what extent that's overstated, but it does help to have the Marshall-Brennan Fellows in there helping to give tours of colleges and promoting college consciousness and then ultimately law school consciousness thinking among their students. We've been very proud in DC that we've had students of ours who are high school students in our classes go on to college, then go on to law school here and become Marshall-Brennan Fellows, and then go and return the favor and to continue kind of this cycle of education. All right, let me just say finally, in addition to this natural and organic pipeline of potential law students, there's another important role that I think the Marshall-Brennan Project can play in this time of real confusion and consternation in American legal education. And obviously we can't get into the whole critique right here, but let me just say that there are a number of things that are being said about legal education now, which the project provides a direct refutation for and a direct answer to. And I don't mean to say that the whole critique of law schools is wrong, because obviously there's a lot right about it that, for example, Brian Tamanaha gets right. Obviously no law school should ever be in the business of deceiving prospective students by cooking the books or changing the numbers around. I mean, that's absurd. But the broadside against law schools now goes much beyond that. And so let me just compare some of the things that are being said to what I think the Marshall-Brennan Project is doing. And I'll close with this. One thing that's being said is that law students learn an esoteric and expert language that necessarily distances them from people in the community. But in the Marshall-Brennan Project, we show that students can master constitutional law by constantly translating and explaining the relevant concepts and terms and values to young people, which brings them closer to the community. I've got a colleague who said to me, I always know when I've got one of your Marshall-Brennan Fellows in class because I call on them, and then they say, well, there are 3 things that you need to understand about this case, and then they take the class over for the next 5 or 10 minutes. So it doesn't have to distance the law students from the rest of the community. It can engage them more deeply in the community. The second thing is that all of the law schools are locked in a ferocious, mean-spirited institutional competition with each other. They're stealing each other's students. They don't work together unless it's to try to engage in illegal antitrust conspiracies, the kind that was busted by the Department of Justice. Again, we are showing that law schools across the country can work together on a totally grassroots, bottom-up basis and help each other to reach out to their communities and to be involved in something that's much greater than any of us could ever do alone. And you know, we're about to hit a tipping point where we become so big that people will start not, you know, asking law schools not, do you have a Marshall-Brennan project, but why don't you have a Marshall-Brennan project at your school? And it's something that is really proceeding in a very collaborative and cooperative way, as the conference out in Colorado, I think, reinforces. It's also said that law school classes are brutally competitive and student life is cutthroat, nasty, and unhealthy. I just want to read to you an email that Maryam received just yesterday, and we get these frequently, but this one comes from a young woman at Washington University Law School, and she wrote, I hope this note comes to you well. Dave Collier typically corresponds with you regarding our chapter at WashU, but as I'm winding down my law school career, I wanted to personally write you and thank you for all of your support over the last year and a half. I'm currently writing a paper for my third year seminar about the potential of literacy to reduce juvenile crime, and I'm referencing your article. I felt compelled to reach out because Marshall-Brennan has been far and away the most educational, inspiring, meaningful, and flat-out enjoyable experience of my entire law school career. Inequality was something I was always passionate about, but it wasn't until I actually taught my own class that I truly got it. I accepted a full-time job at the New York City Law Department in juvenile justice, but because of my work with the project, I have deferred for a year to complete a master's in education at Harvard. I'm sure you know how important Marshall-Brennan is to every kid in the classroom, how much joy they gain from it, and how much of a difference it makes for all of us. But I also want you to know how tremendously meaningful and even life-changing it can be for the law students as well. Thank you for helping to make this experience possible. And you know, we get that kind of thing all the time. We are actually improving the quality of forced law schools across the country. Okay, and finally, the thing that's said is that law students are all grasping for the golden ring of jobs at the big corporate firms and are fundamentally frustrated by the inadequate supply of such jobs, and thus they are coming to regret their decision to go to law school in the first place. Well, I think that we obviously have students in our program who are headed in that direction, but not all of them, and probably not most of them. Not all law students want to be corporate lawyers on Wall Street, or where else for that matter, and there are ample and fascinating opportunities for young lawyers committed to constitutional thought and practice to find employment, clerkships with judges who value literacy and public involvement, school boards, school systems, in the representation of students with problems like individual disabilities, discrimination, with civil rights groups and civil liberties and so on. The Marshall-Brennan Fellows express tremendous satisfaction and pride in their work. They do not hate law school. They do not think it was a decision. They do not think that the culture of law schools is cannibalistic, and they're connecting to the best impulses and traditions in law school service. And so I think that if nobody else is willing to stand up for the law schools, at least we in the constitutional literacy movement should be standing up for the law schools. And you know, I want to say finally that that constitutional literacy movement should play the same role for public domestic law as the human rights curriculum serves for international law. The constitutional literacy drive and curriculum really should be the moral touchstone and the source of energy for the domestic law curriculum. So with that, I will close, and I really thank you guys for your indulgence. I know it's no fun watching a big screen.
Professor, thank you very much. Can you still hear us here in the courtroom?
Yes, I can.
Okay, great. We'd like to take some questions from the audience. And if you could, please speak up and speak loudly enough for that microphone to hear you. So I'll just kick off the questions. Professor, you mentioned that the mantra of the Marshall-Brennan program is one nation, one constitution. Right now we seem to be in a period of great political division. Do you feel that the Marshall-Brennan program can help repair that schism and bring us back together on issues, whether it's constitutional or political?
Yeah, I should say when I said it was our mantra, I think it just occurred to me when I was working on this a couple of days ago. So we haven't really used it yet. The one person, one vote, one nation institution. And I do think that it offers us a way forward, in a time of very fractured feelings all over the country. We're not one political party. We are not one ideology. We are not one race. We are, not one religious belief. But we do have one constitution, and we challenge ourselves to struggle under that constitution, and to resolve conflicts in that way. I think Maryam and Steve know this story, but when the New Dow decision was handed down by the Ninth Circuit about one nation under God in the allegiance, I made the mistake of going on the O'Reilly factor to discuss the decision, and he said, well, what is it about you liberal law professors that you don't want, to have one nation under God in the Pledge of Allegiance? And I said, well, I'm an originalist, and I want to go back to the original Pledge of Allegiance, which didn't have one nation under God in there. And he said, well, we've done it for 50 years that way. If it's not one nation under God, what would it be? One nation under what? And I said, I don't know, one nation under Canada, perhaps? Really, what about one nation under the Constitution? Because that is the governing structure. And, and I think that's what our constitutional literacy movement has to offer the country, that what are the basic values, what are the points of consensus arrived at, and then where are the differences and where are the conflicts, and then we teach those too. And Steve found us a wonderful speech by Justice Brennan saying you don't just teach the easy stuff, you teach the hard stuff, and you teach the points of conflict as well as the points of consensus.
Thank you. Other questions? All right. Well, Professor, thank you very much for your time. We appreciate it. Thank you.
So, Jill, do you want to explain what's happening?
So, Jamie, we're just going to minimize you so that you can continue to listen to the conversation, but we are going to move on to the next presentation. And so I'll just start the slideshow for that. Good afternoon, well, morning for here. I'm from Washington, D.C., and balancing the time differences constantly to make sure that keep things going over there as well. But it's my pleasure to be here with all of you yesterday, primarily and especially today. My name is Maryam Ahranjani. I work at American University Washington College of Law, my alma mater, where I served as one of the first Marshall-Brennan Fellows some years ago. And I have had the great pleasure for the last few years of taking the reins from Steve Ormeal, who ran the project for a number of years, to really conceive of our next steps, and particularly for spreading our project around the country. And so it's my pleasure to work with law professors and law students and all sorts of school administrators, teachers, anyone who's interested really to learn how to start a chapter at their local law school. And we now have 19 chapters around the country. We have 5 more that will launch in the next year or so, and I anticipate that at some point, our vision will actually be that every law school will have, as Charles suggests, some form of law students going into local public schools to teach about the law. So we're very proud of the work that we do. However, we're very aware of the fact that there haven't been really any serious academic studies of our work. And so I certainly, for many years, have been worried about this, thinking about it. I think we all had, but being the on-the-ground person, thought, okay, we have to finally do something about this. So I decided that we should do a study of our at least 1-year cohort of our high school students to figure out what are we trying to get them to learn, first of all, capture that into a survey, and then administer that survey to them at the beginning and at the end of our course, as Laura mentioned, pre-post test surveys. And I have, beyond basic statistics classes in college, no background in this. So I was lucky enough to be joined by Jeff Shook, who is our new colleague running a Marshall-Brennan chapter at the University of Pittsburgh, an alumnus of our law school, who not only has a law degree, but also a PhD, and is a tenured professor at the University of Pittsburgh and has done lots of social science research. And so he was able to help us really more come in after we'd already, unfortunately, designed the instrument and administered it. And then Caleb Medeiros, who's not able to join us today, worked with me that year during the 2010-2011 academic year when we administered and collected this data under a fellowship similar, I think, to the one that Laura has, to be able to really make sure that we were capturing as much data as we could. So we'll just give you some basic information about what we had planned to do with the survey. Jeff will explain to you a little bit about the results that we found. We do have copies of the outcomes as well as the questions for those who are interested, but we didn't want to bog you down in too many numbers and rather sort of give you some conclusions. So we will share the pre-post test data. As I mentioned, again, it was just during one academic year. It was extremely challenging to design and administer and then collect all of this data. Basically, Caleb was on a near full-time fellowship to work on this and spent about half time for that year working on this. So it was this very serious undertaking. We also then will present, as I mentioned, some conclusions and suggestions, and then hopefully we'll have a few minutes at least to talk about some very important questions I think that come out of this research. So the pre-post assessment came out of a need to understand how we're doing, and that's the very, as educators, we always want to make sure that we're doing what we say we're going to do. And so that always, I think, was something we were thinking about. But also, we certainly wanted to be able to tell school districts, teachers, administrators, how exactly this program benefits students. And so we thought we needed some numbers to be able to do that. We've also been lucky enough in Washington and to have enough connections to be able to pursue outside funding for our work all these years. But we know that some of our chapters are a little bit more limited in the resources that they have access to, and that funders really are looking for numbers to be able to really function. Now, of course, we all know the dangers of all that, and we talk about it in our paper about over-reliance on data and whether it all really means anything. But the reality is that people ask these questions about, how effective is your program? We had 41 total questions, and they focused on 3 really different areas. One is knowledge, really the thick constitution, as Professor Tushnet would say. And then critical thinking, which is something we work very hard to foster with our students, primarily through moot court. And finally, civic participation. And we administered these questions through the vehicle of the law students in each of the classes, our teaching fellows, but designed on protocol that myself and Caleb came up with. So I'm going to hand it over now to Jeff to explain the analysis.
Well, thank you, Maryam. So what I'm going to do in the next few minutes is talk about what we did with these data, highlight just some general findings, and then talk about the limitations, and then turn it back over to Maryam for more discussion around this paper. So again, we've talked about the pre-post design. It's common in the social behavioral sciences, and you're looking before and after an intervention to see if there's an effect in that intervention. Key to doing this is you want to include in your analysis those individuals who are both did pre and a post test. So when we did this, we got a match of 48%, which there's no industry standard, so to speak, in the social sciences with regard to a pre-post, what a good. Ideally, you want it to be as close to 100% as you possibly can. There's a lot of reasons, and I'm not going to go into depth. We go into them in the paper, and we're expanding on them in the paper. There's a lot of reasons. We see, in Pittsburgh, in DC, we see a lot of drift in and out. We see a lot of absences. So there's a lot of issues. The fellows work hard. I mean, there's a protocol. They work hard to try and do this, but again, it's something we're going to have to do better in the future if we continue to do this work. I'm going to really talk briefly about what we did. I did the analysis, and it was pretty basic, pretty straightforward. So we did what's called a paired samples t-test. And really, the focus here is to determine at a certain level of confidence whether there's a mean difference from the first to the second, or whether that mean difference from the first to the second is not equal to 0. So whether there is a difference here. And what happens is it produces this thing called a t-statistic, and then we can calculate a p-value out of that. And generally, if the p-value is less than 0.05, then that's an industry standard that we determine that to be a significant difference. So it's you know, we're confident that it's not occurring just because of chance alone. And so you have the handouts. I'm not going to go through the specific numbers because we could be here for a while if we went through those. You can peruse those. We can talk, take comments and suggestions. What I want to do now is just hit on some general bigger points that we pulled out. One is that knowledge at baseline, so at the pretest, was generally pretty low. It varied across these questions, but I think in general it was pretty low. One of the things that we found in these data is that the students had a choice. So they had the questions that you'll see in the handout. So they had a choice to answer it or to not answer it. And what we saw from pre to post test was a big decrease in the number of students not answering. We interpret that very positively in terms of, you know, they're more confident to offer an answer at least. Then what we also saw was that there were statistically significant gains from the pre to the post test across the board. 38 out of 41 items. In I created 3 sort of aggregate measures putting items together, and there were significant, those were significant as well. So a couple of the questions where there weren't significant, the jury, question willingness to serve on a jury, voting, intention to vote, that was actually incredibly high at the pretest, 81%, went up to 87%, but we can't include. And then the other one was, do students have constitutional rights? So that was quite high as well. We didn't see a change. But across the board, the other questions, we did see a statistically significant increase. Again, we interpret that very positively. One of the things I always, with my students, just with everybody, you learn, just because something is statistically significant doesn't mean it's meaningful, right? So that leads us to look at the data and trying to interpret that data and to put meaning to it. So then we have to actually, you know, take a peek and see, okay, are we getting what we want here? And so what we found is that the magnitude of the gains from the pre, so the number answering correctly from pre to post test, it varied, that increase, but it was large across a lot of the questions. And in particular, it's large, you'll see questions around Supreme Court cases, knowledge of the Supreme Court, moot court participation, critical reasoning and thinking skills. There were questions around those. So we see this variation across the questions. Though one of the things that I'm very interested in, I teach a lot, primarily teach in school social work, but I teach the Constitution, and I'm really interested in teaching about structured government, how our government works. Those weren't that high. We didn't see quite as much increase, and we saw a lower level of knowledge at the post-test than some of these other items. And again, it may be the focus of the classes, but it's something for us to think about, sort of these patterns that were revealed in the data and how we can use it to think about what's going on in the classroom. I want to just hit on a couple, anytime you do research, as people have talked about, there are numerous limitations. That's one of the things you learn as a doctoral student and into your career. There's no perfect study out there, right? It's all just pieces, essentially. You're developing these pieces to a bigger story. And so, you know, the match rate, we want it to be higher, as I talked about. There's no comparison group. So typically you'd like to have a comparison group to say, well, the intervention, you know, we can then point to that the intervention caused these results as opposed to something else. Now, we can make strong arguments at this about the intervention, but we can't conclude that. We don't have this was just about knowledge, the questions. We don't have any demographic characteristics in here. There's nothing such as attendance. We know attendance varies quite a bit, so being able to link attendance. So we're not able to, you know, we talk about this, you got the top line numbers, but really it's fun to look underneath those and to really understand more what's going on. We can't do that with these data. Question, wording, and focus. And I think we've talked a lot about that this morning. We talked about that last night. One, how you word these, I mean, survey research is a difficult thing to do. I mean, question wording really matters. Question ordering, these things really matter. So, you know, we could lose a lot just with poor questions. But there's also the focus of the questions. So, as we said, a lot of this is on knowledge. that we focused, or critical thinking skills. There's some measures around civic participation, but we agree we need to improve those. Is this the right stuff to focus on, right? Or the question, maybe it is, but maybe we need more. Maybe we need to assess other things, as Professor Tishman talked about and other people talked about. Maybe there's other things that we need to assess as well. So that's something we'll have to think about. There's always, again, that question of knowledge to something else. So with my doctoral students, with a lot of my students, it's always the so what question. Okay, you got this finding, but what does it mean, right? Can you relate that? Can you provide meaning? Despite these limitations, this is a start, right? As Maryam said, we've got now some data. I mean, I'm trying to raise funding in Pittsburgh, and I'm told we want to see numbers. So, okay, we're going to produce numbers. We're doing this in Pittsburgh as well, so we want to produce these numbers. But I think what it's also doing, and in this conversation, is raising a lot more questions that Maryam now is going to turn to. Yep. Yep.
So I'm very conscious of the time and don't, this is not a law school class where we can spend the next hour debating these questions. But I think that the central question in sort of thinking about yesterday, our directors meeting, as well as Martyn's talk and the purpose of today, really the one question we wanted to kind of talk about as it relates to our research is whether we're striking the right balance between civic and constitutional knowledge and, on the other hand, action in our curriculum. That's related to the question of how do we actually measure that? Because we can have sort of anecdotes like the wonderful email that I got from Kaylee Berger the other day that Jamie read to you, and anecdotes that I get like that, thankfully, on a very regular basis are wonderful, but are they really, statistically significant and reliable? So I don't know if folks in the audience have questions, answers to this question, or any thoughts you'd like to share in response to it. Yes, Jill.
I just want to say, I think it's really important for us to try to gather this objective, quantifiable evidence, but let's not throw away anecdotal, narrative, qualitative, and common sense wisdom that we have from these programs. We see these kids in action, the high school kids. We see the law students. We see the impact of a lot of this work, and that's not unimportant. We can describe it. We're doing some of that here. We do it in our communities, and it's important.
I completely agree with you, I guess, and that takes us to a question that we had on the second side with additional questions was, are there other forms of data, in quotes, that we can collect? And are there better ways to collect that, perhaps, that, I certainly could do a better job of it. I'm not quite sure how to do it, though. Yes, Laura?
Just kind of piggybacking off of what you said, I think that some of the self-assessment that needs to be done for these kinds of programs needs to mirror the 6 proven practices that we know lead to the best kinds of civic engagement programs. And so I think those valuable self-assessments need to be, I think we have the data to know what kind of interventions are working best, and I think we need to take a step as programs to build in time to evaluate how well we're using those 6 proven practices and begin to not just track what student outcomes are or law student outcomes, but as programs, as a program, are we following what we know from the research is more efficacious?
Yes.
Typical of me coming at this from a position of ignorance. The Marshall-Brennan project has a goal of enhancing understanding of the Constitution in high school students. Any other broad brush goals?
Yes, actually, and in our paper we sort of outlined specifically, at least in DC, what we have promised to the school district. And in DC, we're lucky enough that the public school system has allowed us to create elective courses based on the 2 textbooks that we have. We have the We the Students text that Jamin referenced and our subsequent book, Youth Justice, that he and I co-wrote with the public defender. And so we had to promise to the district what our goals were, at least. And I imagine that the chapters sort of share similar ones. In fact, we've discussed that and sort of formalized that in a list of essential elements that we have on our website. But the goals include teaching students to read and understand Supreme Court cases, teaching them to understand basic constitutional principles such as separation of power, not in detail, but at least to be able to say what the 3 branches of government are and their basic functions. To teach critical thinking skills and to be able to apply their knowledge of the cases and demonstrate that through critical thinking. In particular, as I mentioned, through moot court. So for those who might be unfamiliar with moot court, basically it's appellate argument. So it requires students to be able to argue their particular factual scenario using case law that they've learned to support their arguments in favor of this particular factual scenario, whichever side they're assigned to.
And that's my pet issue for high school students is public presentation.
Yes.
Is that a big goal of Marshall-Brennan, is to teach them public presentation?
Very much so. And we know that, across the board, Americans, the number one fear of Americans when polls are done is public speaking. And so certainly that's true of young people who are dealing with all sorts of, insecurities. And so we see tremendous growth in the young people, and we work very hard to start with them wherever they are. So some people are too nervous to even get up in front of the class to say, hi, my name is X. So we work with them, and scaffold the learning up to getting to be able to do an actual oral argument in a room like this to law students, lawyers, law professors, judges, and across the board, most of our chapters are running local competitions. So they have a mechanism for selecting students from each of the high schools in which they teach. We do in-class competitions in every single classroom, and the winners of our in-class competitions then come to our citywide competition. All the winners across the country of the citywide competitions then, or local competitions, come to a national Marshall-Brennan High School moot court competition, which we're in this will be our 5th year of hosting it.
Any goal to measure increase in public speaking skills? Have you even thought of that?
That's interesting.
To me, that's the most broadly applicable skill that you can gain from doing stuff like that. That's why.
That's a good. I believe that if not in our, we do a survey of our high school, of the students in the high school moot court competition, and so I'm forgetting which one had a question about whether they feel more confident in terms of oral argument, and so we do ask it, but I'm not sure if we did it at that local level. Or yes.
One of the skills that I think my students really got out of it this year, because they did the program, was the ability to put together information with what you're talking about. So reading through the case law and then saying, okay, which one of these cases is applicable to my argument? Students are not able to see a bunch of information and put it together. So this, I think, that was one of the most valuable skills. Is there's a lot of different information here. You guys are on different sides. You can't. Some of you could use the same information, but it's how you make the argument with the information, and that was really, really crucial to what I think they got the most out of this year.
Other thoughts or questions?
We probably have time for about one more.
Okay. Yes.
So just looking at the bottom or the previous bullet point about standardized testing and whether or not it's valuable or realistic for assessing the efficacy of the program, I know that at least for me, as you know from talking with me at length about this, my 3rd year in law school was the most meaningful because I was not in a law school classroom. I was out in clinic and I was teaching in Marshall-Brennan, and I was not in the classroom. And so that practical experience made the entire law school experience worthwhile for me. And so I think I understand the need for the numbers because that's where you pitch your program and that's where you get money and that's where you get funding. Thinking about that, and is it very valuable or realistic? I don't know, but it kind of made me think about when I was talking with Conrad last night, who we're going to hear from, about how he does this video montage type stuff for mitigation and sentencing and things along those lines. And I'm wondering if anything has been done, and I'm sure you've thought about this stuff if it hasn't already been done, about going in and just videotaping or just see what happens at these moot court competitions or what happens actually in the classrooms themselves or what parents say or just how it affects people in the community. I know that one of the best experiences and moments of being a teaching fellow was when we had the moot court competition and seeing this kid that I wanted to strangle every single classroom get up there and advance in the rounds, and seeing his classmates from school that would ridicule him all the time and just say, Adrian, be quiet, sit down, getting so behind him and cheering for him and being really supportive. Those are the moments that I think are really impactful. And so I'm wondering, I don't know if numbers are realistic or valuable. I know that for me they're not. They don't mean anything for me and my practical ability to do my job or to be a person or to relate to other human beings. So I'm wondering, is there some other way to sort of present this information and what it does? Because we know it does, right? We know how amazing it can be and that it is, but are there other ways where we can put it out there and sell it?
Yeah, and I think that sophisticated funders or, you know, folks who've been in the schools particularly that we serve for, you know, understand exactly what you're saying, that those moment, that moment where a student who really didn't engage in school at all suddenly becomes like excited about learning is huge and life-changing for not only that student but the others that are watching that person. So we certainly value all of that, and you know, when we write grant applications, you know, I tell lots of anecdotes like that. I think what we've realized, though, over time is that there still are people who want numbers. I don't like that. I wish that wasn't the case. There are chapters where literally they just are not able to move forward in securing support without having something that seems more data focused.
And I totally understand that. It made me think of the conversation I was having with Conrad about having something visual to see. It's not, you know, it's one thing where my client can stand up in sentencing and say, this is why you shouldn't send me to prison. But if the judge actually sees him interacting with his son, that might be a little bit more persuasive. So I was just wondering.
And we have to think of the ways that these things can go hand in hand too, right? Got the numbers and the anecdotes. I mean, it makes it so much more powerful when you can say, yeah, we got these stories, but it's systematically backed up across the board. So I think there are ways for us to think about it. And I think Jill's questions are a really important one. You know, we don't want to get, in your point, we don't want to get too caught up in the numbers, right? I said it's only part of the bigger story, telling the bigger story. But I think we need to think about those pieces and trying to package them together more effectively and systematically.
Another byproduct, and I see your question, I'm not sure that we have time, but another byproduct of like forcing ourselves to look at data is just it forces us to ask questions about what are we teaching? Are we teaching it well? How can we adapt to changing times and adapt the curriculum to reflect what the students' needs actually are and their interests actually are? So it's good on the program level too to kind of force us to have good conversations.
Mine's just a really brief comment, and you may already be doing this in the sense that we want to always connect it to the result at the end of the standardized testing, and I'm looking at that third question you have up there, but when you're framing something, do you already frame it in connection to standards? Because, you know, a huge language arts standard is that we are orally presenting ideas. You know, and so in framing them connected to the demonstration of the standard through a different assessment would seem very, and you may already do this, but connecting them would be very big,
yes.
Certainly in the current form of education where there's the tension between, yes, we want standards, but we don't want standardized testing only to
yes.
measure it. So that would just be.
And I will say this is one area also where there's a little bit of a disjuncture between the law and education is that, you know, from my point of view, frankly, the standards, and because we're engaged in this for the long term, the standards are so constantly changing that it's hard enough for us to keep track of what we're doing at the law level, make sure we're keeping on top of the cases that you know, we're aware of the standards.
Benefit of the Common Core.
Absolutely.
It's a huge benefit.
And we certainly read them and are aware of them. And a couple of our chapters have engaged in a very serious undertaking of aligning their curriculum very closely with their state standards, for example. And now Common Core is, you know, much bigger of a deal than it was when they did that 3 or 4 years ago. So I appreciate that. I think it's just a very real limitation for us to be able to align it more
connecting it to a frame. If you're framing a video or you're framing something
yes.
that this is a very real, tangible assessment of this standard, and
that's a great idea.
That's kind of just.
Well,
Thank you.